Days after activists and citizens took to the streets to protest the controversial Supreme Court ruling, which essentially broadened the definition of the Aravallis to allow mining of hills above 100 meters, the Supreme Court today has stayed its earlier November 20th judgment. Hello and welcome to The Print. This is Khadija Khan from New Delhi, and today we are going to be discussing why the Supreme Court vacation bench, led by Chief Justice of India Surya Kant, took suo motu cognizance of the Aravalli's hill issue and hit pause on its earlier ruling, which was given by a Gavai-led bench nearly a month back. Usually, when a court takes suo motu cognizance of an issue, it means it's reopening the issue, often on its own, without any party approaching it with a petition to do so. Today, a bench led by Chief Justice of India Surya Kant, consisting of Justices J.K. Maheshwari and Augustine George Massey, took a suo motu cognizance of the issue after the earlier order sparked major uproar. In the interests of justice, we direct the recommendations of the committee and the findings of the Supreme Court to be kept in abeyance until the case is taken up on January 21st, and all the states have responded, the court said, while adding that the expert committee's recommendations will also be put on hold. The court also proposed setting up a high-powered committee of domain experts to re-examine the earlier reports. It also sought responses from the central government and the concerned states like Rajasthan, Haryana, Delhi and Uttar Pradesh, asking them to come up with their responses by January 21st next year. At the outset, Solicitor General Tushar Mehta, appearing for the centre, told the court that there was some misinformation going around in this case. Underlining the need to get clarifications in the matter, the court then suggested setting up a fresh committee, which would take a look at the recommendations given by all the earlier committees, specifically with regard to the definition of the Aravallis. The court also observed today that the proposed definition of the Aravallis created a structural paradox where supposedly protected territory was being significantly narrowed. It also expressed the need to answer questions such as if regulatory mining could be allowed in the Aravallis, and if so, to what extent. Underlining that the need to ensure ecological continuity is not compromised, the court said that an exhaustive and scientific determination of the matter was required, and then went on to propose the idea of a high-powered committee to consider the reports submitted by the previous committees so that the issue is holistically examined. The new high-powered committee will be required to carry out a detailed identification of the areas which would be excluded from protection. It would also have to analyze if the regulatory mining could result in ecological damage to the region or not. The now stayed ruling. On November 20th, a three-judge bench led by former Chief Justice of India B.R. Gavai expanded the definition of the Aravallis in such a way that all hills above the height of 100 meters would be covered in its ambit, which in turn would lead to mining in more and more areas of the Aravallis. In doing so, the court had taken into consideration the definition given by a court-appointed committee, which recommended the Aravalli Hills to be defined as any landform in the Aravallis having an elevation of 100 meters or more above its local elevation. On the other hand, the Aravalli range was defined to be a collection of two or more such hills within 500 meters of each other. This could lead to disastrous consequences, the amicus curiae had argued, saying that most hills would now be opened up for mining and the Aravallis would lose their continuity and integrity. Significantly, in November, the bench, also comprising Justices K. Vinod Chandran and N.V. Anjaria, had ruled against a complete ban on mining in the Aravallis, saying that it could lead to the creation of land mining mafia and criminalization. Undisputedly, the Aravalli hills and ranges exhibit ecological fragility and include significant biodiversity, the court had said, while adding that these hills act as a green barrier which prevents desertification or degradation of fertile land in the Indo-Gangetic Plains, Haryana, and western Uttar Pradesh, making it clear that mining activities would still be prohibited in protected areas like wildlife sanctuaries, tiger corridors, and economically sensitive zones. The court also said that in cases where there is mining of critical, strategic, and atomic minerals, an exception could be made. The bench also barred the grant of new mining licenses in the region until a management plan for sustainable mining or an MPSM is carried out, as was done in the Saranda forest area in Jharkhand. In the Saranda forest case, the court had said that Saranda should be declared a wildlife sanctuary given concerns of illegal mining and ecological conservation. In the present case too, the court recalled its Saranda ruling and noted that the Environment Ministry had got a study done by the Indian Council of Forestry Research and Education based on which a plan was prepared for sustainable mining in certain districts of Jharkhand. After an ecological assessment which entailed digital mapping, suitable areas were identified that needed ecological protection so that conservation of biodiversity was a priority there. Lack of a definition of the Aravallis and various court rulings. In the present case, the Supreme Court clubbed two similar matters, that is MC Mehta versus Union of India and TN Godavarman versus Union of India, which were before it and both of which related to the Aravallis. While the former related to mining activities in Haryana, the latter was listed before the court in January last year and was confined to mining activity in Rajasthan. To avoid conflicting orders in both cases, the pleas were clubbed and placed before the CJI. On 10th January last year, the court had directed the Central Empowered Committee or the CEC, which is an expert committee that usually acts as a watchdog on environmental issues, to examine the issue of mining in the Aravallis after consulting with geology experts. Among the many recommendations given by the CEC in its report last year was mapping the entire Aravalli range in coordination with the Forest Survey of India within 6 months' time. The committee also suggested an analysis of mineral extraction levels, available infrastructure, and a look at the environmental concerns. Till this exercise is completed, no new mining leases or renewal of old mining leases should be allowed in the Aravallis, the CEC had stated in its report. Significantly, the CEC had said that mining should be prohibited in certain protected areas, including tiger reserves, which have been declared protected under the Wildlife Protection Act of 1972, and the eco-sensitive zones, which refer to lands within 10-kilometer radius of national parks and sanctuaries. In May, when the court again took up the matter, it said that mining activities within the Aravallis needed to be addressed jointly by the Environment Ministry and the 4 states through which the hills run. Interestingly, the court noted the lack of a commonly agreed definition of the Aravallis since different states have different definitions. It then directed constituting a committee for providing a uniform definition of the hills and ranges. On 3rd October, this court-appointed committee suggested a very broad definition of the Aravallis at odds with the one given by the FSI and the amicus in this case, which included all the hills of height 100 meters and above, which in turn would lead to more mining in more areas of the Aravalli hills and ranges. Agreeing with the committee's definition in the present case, the court had noted that except in cases of critical, strategic, and atomic minerals, mining activities would still be prohibited in inviolate areas. It also appreciated the panel for doing a commendable job and prohibiting mining in core areas. And that brings us to an end of today's segment. For more legal updates, stay tuned to The Print.